Breaking news. Welcome to today's headlines. Judiciary is finally captured by President Buhari. Judiciary is finally captured by President Buhari, Kuriwal speaks. To my dear listeners, from wherever you're listening from, please stay tuned as I read today's news. Vexed by the decision of the Court of Appeal to grant the prayers of the President Muhammadu Buhari on the judgment made by the Appellate Court, quashing all charges filed against the detained leader of the indigenous people of Biafra, IPOB, Mazi Nnamdi Kanu, which government disobeyed before deciding to appeal. The judiciary is described as a captive of the executive arm of government and therefore has lost her voice as the last hope of the common man. In the words of the Human Rights Writers Association of Nigeria, Huriwa, said, by their cowardice manifested in the granting of the stay of execution to a disobedient appellant, the Court of Appeal has justified the resort to self-help measures by disenchanted citizens, since it is no longer possible for justice to be obtained in the court of law and complied with by the government, and then the same court will certify the gross indiscipline and treachery of the central government in flouting the unambiguous orders of the court made in compliance with Section 6 of the 1999 Constitution of the Federal Republic of Nigeria. Prominent civil rights advocacy group, Human Rights Writers Association of Nigeria, Huriwa, which condemned the capitulation to the whims and caprices of the dictatorial president of Nigeria by the Court of Appeal. Huriwa wondered why the court did not insist that the federal government first obeys the judgment before appealing, since it is a matter that touches on the criminal breach of the constitutionally guaranteed fundamental freedoms of citizen Nnamdi Kanu, who has remained in solitary confinement at the dungeons of the Department of State Services for nearly 2 years and has reportedly contracted a life-threatening ailment whilst in detention. Huriwa said there is absolutely no reason why the court couldn't have compelled government to comply by a decision rather than being blackmailed into shooting themselves on the leg and thereby amputating justice. Since the rest in the appeal against the judgment of the appellate court won't be dissipated if Nnamdi Kanu is left to enjoy his freedoms whilst the Supreme Court hears the federal government appeal. Today is indeed a calamitous day for the Nigerian judiciary, whereby the wheel of justice was derailed by political correctness and fear of the unknown. Huriwa is appalled by the hierarchy of the Court of Appeal, was also provoked by the decision of the 3-member panel of justice to quash the charges against Nnamdi Kanu, that it reportedly made punitive transfer, affecting a member of that panel even before the belated application for stay of execution was filed, just as the rights group questioned the moral high ground of the federal government to rush to the appeal court after the federal Attorney General and Minister of Justice Abubakar Malami has used media platforms to impugn and discredit the panelists who freed Nnamdi Kanu. and maintained publicly that the president won't release Nnamdi Kanu, even when the Court of Appeal had expressly ordered that all charges pending against the detained self-determination campaigner Nnamdi Kanu were comprehensively annulled. Uriwa lamented, however, that despite the publicized notice of intent by the federal government not to ever respect the judiciary of the Court of Appeal, the same Court of Appeal certified the legality and the act of impunity and treachery of the federal government when the Court of Appeal sitting in Abuja on Friday suspended the execution of its judgment that ordered the federal government to release the leader of the indigenous people of Biafra Laipo, Nnamdi Kanu, from detention. Uriwa recalled that the appellate court, in an unanimous decision by a three-man panel led by Justice Arunat Sanami, granted the application federal government brought for stay of execution of the judgment pending the hearing and determination of the appeal it lodged before the Supreme Court. However, the appellate court ordered federal government to, within 7 days, transmit the record of appeal as well as its verdict on the matter to the apex court to enable speedy determination of the case. Uriwa recalled that appellate court had last Monday reserved its ruling on the application federal government filed for the judgment that quashed the entire 15-count terrorism charge it preferred against Kanu not to be executed, pending the determination of an appeal it has lodged before the Supreme Court. Carpeting the Court of Appeal for making itself an effective political hostage and captive of the executive arm of government headed by the dictator President Muhammadu Buhari. Uriwa said the decisions to suspend their own well-conceived and legally sound and well-grounded judgment amounted to judicial suicide by the Court of Appeal and is similar to hitting the death nail on the coffin of judicial independence, even as Uriwa said the appeal court's decision is shameful, laughable, and irrational. To my dear listeners, please do drop by at the